Good afternoon, friends. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to tell you about main differences as I see them in immigration policies and process for the green card in the United States immigration in 2019 and 2020. So the year of 2019 was mostly defined by litigation. Basically, when something needed to be done or the people wanted to push back against the policies that were changing and policies that were not favoring immigrants, they would sue the government. In the United States, it's very popular to do that. And those lawsuits were very popular between the groups that would protect the rights of many and by individuals. For example, somebody wanted to get a decision on a case that's been pending forever, or someone would be disagreeing with the denial, saying that they didn't have a fake marriage, they had a real marriage, or that they're eligible for adjustment of status, or that they're eligible for H-1B visa. So litigation was everywhere. Through litigation, in 2019, we were able to reach such important results as eligibility for special immigrant juveniles under those who were under 21 when the process started and not under 18. Currently, because of the litigation that was filed in 2019, there was a big win on bond for those who are filing for asylum at the border. Also, litigation unfortunately brought in public charge rule, because what happened after the public charge was implemented, there was a lawsuit, and for some time the implementation of the public charge new rule was on hold. But then through litigation, the United States Supreme Court stated that the public charge rule in the meantime should proceed pending the final result. And of course, there was litigation about travel ban. In general, in 2019, interviews were very common for all types of adjustment of status cases. For those who filed based on one asylum and marriage and employment, so interviews were the norm. Increased processing times, we had to wait for a long time for most cases to come to a resolution. By the end of 2019, we did see that citizenship cases for naturalization started to be processing a little bit faster. And then we entered 2020. And when we entered 2020, of course, for the first couple of months, we were still rolling, and then March came and big changes came because of the coronavirus. And coronavirus came. And now to win one's case, it's not enough for a lawyer to be smart, to know the law, or to fight well for their clients in the legal field. We face the reality that lawyers also have to use protection if they go to immigration courts. Otherwise, they will not be allowed to enter. Coronavirus changed the way the cases are being considered. I've heard that nowadays, actually, the United States government is considering waiving interviews for employment cases. I even heard that some marriage cases interviews were waived. Not sure if that is true or not, but some lawyers do state that. The fingerprints in connection with employment authorizations, if a person was fingerprinted before being waived. Of course, the interviews, all in-person business so far has been canceled. We do not know exactly when it will be resumed. So the United States government is actually working to eliminate that backlog that the coronavirus is creating. They are trying to do something like waiving the interviews that are unnecessary. But I anticipate that this situation, of course, is going to cause tremendous increase in processing times for many cases where interview is a must. For example, cases for asylum. In asylum situation, we already have a big backlog, and now it's going to increase because asylum offices are closed. So that's where we stand right now. There is not much positive in this situation. Basically, if you're filing your case in 2020, you're filing for adjustment of status, you do also have to deal with the public charge situation, Form I-944, and that form does not provide any exceptions for coronavirus, meaning that you still have to make your best to comply with all the requirements and attachments that you need to produce to file this form. And of course, right now it can be very difficult, but basically the biggest difference that we see is that I anticipate USCIS will be changing some of its policies in order to be processing cases remotely without the interview or personal contact as much as possible, just like it's already been told to us is going to happen in immigration courts. And immigration courts, as you may be aware, right now closed for non-detained cases. Detained cases are still being heard just because there is a situation with detained cases. It's that when a person is detained and he or she has a right for bond, it's essential for that person to have that hearing done because they can get out of jail because of that hearing. So that's where we stand. These are the main differences, and I'm going to keep you posted as the time goes. Hopefully, we're going to hear about improvements in our immigration system pretty soon. Thank you.